In construction projects, many contractors understandably do not wish to be locked into firm pricing promises to the owner. I'm talking about a fixed contract amount or a stipulated sum that's set in stone that the owner is going to pay the contractor, and in some cases it could be a guaranteed maximum price, where the contractor faces the risk of cost overruns if the project winds up costing them more to execute than they planned. And I don't begrudge general contractors for that, instinct. General contractors have lots of risks. And, this isn't a question of morality or truth or justice. This is a business deal. These are negotiable business terms. My issue, though, and the reason why I'm recording this video, is because I run into situations a lot where general contractors say that they cannot give reasonably firm pricing, for one reason or another. And, sometimes that's true. If architectural or engineering drawings are in their earliest stages, if we're talking schematic design or, earlier mid-design development, that's actually completely understandable for a contractor to say, I can't give you pricing. How can they price a design that's incomplete? How can they put a price tag on something that doesn't exist yet? And it's very common in commercial construction projects for projects to be fast-tracked for, the site work and the civil work and, foundations to be dug and poured and all of that sort of early phase work, to be executed before the design is entirely complete. And I think that fast-track approach is great. I'm not here to say that you shouldn't do it. I commonly counsel my real estate developer and owner clients on how they can go about safely fast-tracking a project, because the reality is, in some instances, it's a condition of their loan that they got to break ground at a certain point, or maybe they got to get a tenant in, and they just don't have the luxury of allowing the design to be completed before it's priced and executed. You got to fast track these things. You got to compress them. So I'm not here to say that it's wrong to start construction before you have a reasonably firm price. The last part of this video addresses the legit observation that contractors can't give you a price when the design is substantially incomplete. And I'm going to talk about how you can deal with that contractually. But the first part of this video addresses the less legitimate song and dance that my owner clients often get from contractors, where the general contractor gives the owner an invalid pretext for, I can't give you a cap on pricing. I can't give you a guaranteed maximum price. I can't give you a fixed fee. So what I'll sometimes see is an owner that'll come to me and they'll say, we're going to use a contract form where, we're not going to have a fixed price stuck in there, whether it is a fixed fee or whether it is a guaranteed maximum price cap. They're going to say, I've already sort of arranged with a contractor that we're going to have another way of compensating them, and it's going to be essentially reimbursing them for their costs without any assurances of what the maximum could be. And they say, the GC says that they can't give me pricing, because the drawings are only 95% complete, or something like that. And to me, that's the tail wagging the dog. So the general contractor's risk of not knowing how to price the last 5% of the work that's not perfectly detailed is going to outweigh the owner's right to have some cap on, what the cost is for 95% of the work, that is already designed and is already knowable. To me, that doesn't fly. There's a lot of ways to address these sorts of, things that are not, easy for contractors to price. One common way is through allowances. So, 95% of the construction costs are going to be set in stone, but because the last 5% are sort of subject to whatever the architect or engineer produces in their final design, there'd be an allowance, a placeholder. It's not exactly a dart thrown against the wall, but it's a generalization. For this line item on the schedule of values, I'm going to guess that it's $150,000 or whatever. And then at the time when the work is executed and you find out what the actual cost of that is, you plug in the actual number in the place of the allowance. And if it's more than the allowance, the contractor gets paid more. If it's less, they get paid less. But the owner is able to get that reasonably certain pricing on the 95% of the design that's already complete. So, to me, if you're an owner and you're going to tell me that you're going to strike a deal with a contractor where there's no limit on what you might pay them, and you're going to say, I got a real good feeling about this contractor, I'm going to say that, 999 times out of 1,000, that is a really bad idea, and there is a way to address it contractually that is going to be better for you. Think about this. Smart real estate developers and property owners are fast-tracking projects all the time, all right? But they're not handing out blank checks to contractors. So it is possible. You have to understand that there are, contractual options for getting a shovel in the ground and fast-tracking the project before the entire price can be known, where the owner can have some price assurance. There are common contract documents that you can find in the industry. The AIA has some. Consensus docs have some. I think the EJCDC has some. There are a variety of different types of contract forms that are produced by industry groups that are in the business of preparing standardized contract forms which address this concern. And it involves the idea that, we're going to sign a contract that's going to specify you're going to do some early work. Perhaps there's an element of pre-construction services in there, but then perhaps there is an element of actual construction work, where we're going to, agree on a price for, because we want you to get started on that, with the understanding that we're going to come to an understanding about what the ultimate cap is on construction costs in a month or two when the design, is completed. And, the contracts have all sorts of provisions about, when the contractor believes the design is sufficiently complete. They're going to provide a proposal to the owner, and they're going to identify their clarifications and exclusions to their pricing and what drawings they're based on. And the owner is going to have the ability then to look at the proposal and accept it, and amend the contract that was first signed in order to add in the pricing for, all the project, including the elements that were unknowable at the time when the shovel needed to go in the ground. But it's also going to say that, if the owner doesn't like what they get from the contractor in terms of the pricing proposal, then the owner has the ability to terminate the agreement, without cause. It specifies what the contractor will be paid for the work that they did and how the project would be wrapped up. And then the owner, with their complete design, would have the right to go out and go through a bidding process and, get firm numbers from a variety of contractors and carry the project forward in that way. And so, there's a wide variety of ways to do this, but they all kind of share those hallmarks. Whether we do it with allowances or whether it is a, non-standardized form, a form of my own creation that gives the contractor a limited notice to proceed with a small amount of work because we want, them to get a shovel in the ground now and is clear about how the owner can pull the plug on the project with that contractor, for any reason, clear termination rights, or whether you go down some of the more familiar paths that are used in commercial construction, including some of these standardized forms. The idea that an owner should have to bear the risk of having no limit on what they could pay the contractor, whether it is a fixed fee, a stipulated sum, or if it's a cost reimbursement contract, a guaranteed maximum price, the idea that there's any reason why a well-advised property owner or real estate developer would run the risk that they might have to pay greatly in excess of what they expect because the contractor can't give them firm pricing, that doesn't fly with me. And so the take home from this video is that while it's not wrong that contractors want to give themselves wiggle room and not get hemmed in, and I don't begrudge them for that, when an owner is negotiating their business deal, it is within their power to strike a fair deal with the contractor that recognizes that there may be some elements of the project that can't be priced now. And, that can't stop us getting in the a shovel in the ground now. But how does the owner protect itself? 999 times out of 1,000, there's a variety of ways to do it with standardized forms and non-standardized forms. And so, if you're an owner of a piece of property, you want to have a construction project, or you're a real estate developer and you're going to come to me and you're going to tell me that you've already worked out a deal with the contractor where they're going to be unlimited in what you might have to pay them, expect to get a lot of pushback from me, on that business deal.